Good morning. My name is Josh Blackman, and I'm the president of the Harlan Institute. It's my honor to welcome you to the championship round of the Harlan Institute Consource Virtual Supreme Court competition. This year, we're arguing the case of Torres versus Madrid. We have a very special panel for you. We have Judge Alice Batchelder from the Sixth Circuit, Judge Chad Radler from the Sixth Circuit, and Justice Pat Fisher from the Ohio Supreme Court. And we have our teams today from Texas and Arizona. Without further ado, I will call the court. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable Court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this Honorable Court. Justice Radler, or Chief Justice Radler, I should say.
Great, welcome everyone. Congratulations to our finalists. This is really quite an honor. You obviously worked very hard and we're thrilled to have you. And you've all gotten up quite early this morning, I think, especially those of you in Arizona. So thank you for doing that. So we'll start, Josh can correct me if I'm wrong, but I think we're starting with the petitioner.
Yes, that's right.
You may proceed.
Mr. Chief Justice, and may it please the court. On July 15th, 2014, petitioner Roxanne Torres had parked her car at an apartment complex. Respondents approached and attempted to open the driver's side door of Ms. Torres' vehicle while she was seated inside. Believing respondents were armed carjackers, Ms. Torres drove forward to escape. As the car began to move, respondents opened fire at Ms. Torres, trying to stop her. Two of the bullets entered her back and temporarily paralyzed her left arm. Ms. Torres sued respondents for violating, by shooting her in the back, her right to be free from unreasonable seizures under the Fourth Amendment. The district court granted summary judgment for the respondents on the basis that Ms. Torres was never seized and could not bring an excessive force claim under the Fourth Amendment. The 10th Circuit affirmed the district court decision, and neither court considered the question of reasonableness.
Using the court's past precedent to guide its analysis, this court will find that the unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment. The requirements for a physical force seizure can be explained through three cases: Terry v. Ohio, Broward v. County of Inyo, and California v. Untitled. The court recognized in Terry that a seizure occurs only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen, as outlined by the court's ruling in Broward.
Wasn't the shooting, the fact the bullet entered a person, isn't that changing their movement?
Yes, Your Honor, it does restrain their movement, yes.
Well, how's that not a seizure then if it's controlling their movement?
Yeah, it is. That is our argument today, is that when the bullet pierced her body, it was an application of physical force that restrained her movement, and therefore it was a seizure.
But if you're correct, then why she kept moving?
Because the restraint of movement was the fact that her left arm was paralyzed, and it was actually that application of physical force itself that also constituted the seizure.
But she kept going. She kept driving the car, right?
Well, yes, Your Honor. And under the court's precedent in Thompson v. Whitman, however, a seizure is a single act, not a continuous fact. So even though she continued to drive, that wasn't, the seizure had already ended by then. The single act that constituted the seizure was when that bullet pierced Ms. Torres's body.
But they didn't control her. She went where she went.
Well, yes, Your Honor. A key part of our analysis as petitioner is understanding that a seizure occurs when physical force is used through means intentionally applied in order to restrain the liberty of a citizen. And that happens when the Fourth Amendment is intruded upon and violated upon. One specific quote from Hodari D: "The mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient." And so the subsequent actions of the suspect after a police encounter with physical force does not hold value as much as the actual physical force used by officers.
In your view of this, does the physical force have to be against the actual body of the petitioner? Or suppose the bullet had simply flattened the tire in the car, so the car couldn't go any further. Would that be a seizure?
No, it would not, Your Honor. A seizure occurs only when physical force is enacted on the person through means intentionally applied.
So how
While there,
much
Yes, Your Honor.
physical force is necessary? I mean, what if Ms. Torres had been wearing had actually not been in the car, but it had been running from the police and had been wearing a scarf, and the officer had grabbed the scarf, but it had not stopped her? Would that be a seizure?
No, Your Honor, it would not. And there's actually a great example from Hodari, that a hypothetical that the court brings up, where a child whose backpack is grabbed, if you grab the backpack, but they get out of the backpack and continue to running, that's not a seizure. And that's for two reasons. Number one, because there was no application to the body. And if there's no application to the body, then there's that requirement that Hodari brings up for the acquisition of control.
And to add on, Your Honor, it's crucial to understand the distinction between a seizure of a person and a seizure of an object. So going back to the car wheel hypothetical, the car would ultimately be seized as the car is reduced to a stop. However, that would not equate a seizure to a person, because a person has inalienable rights and constitutional rights that would be violated if physical force were enacted upon her.
Well,
So,
following
Counselor-
up on Judge Batchelder's question, assuming the tire was broken, right? And then the police surrounded the car, but haven't touched her yet. Is that a seizure?
Well, Your Honor, there are two types of seizure, a show of authority seizure and a physical force seizure. So under your hypothetical, if no physical force has been enacted on the suspect, then no seizure occurs by physical force. However, if we look at the show of authority seizure, if the show of authority asserted by police officers is surrounding her car with armed weapons, if she submits to that show of authority, then a seizure occurs. If she does not, however, no seizure occurs until physical force is applied to the suspect.
So seizure's up to the suspect, not to the police.
No, Your Honor, and actually from what my co-cousin just said, that it's to expand on that, the seizure is not about what the suspect does. And this is actually a problem that comes up with our friends on the other side, that their view is that the problem is the seizure should be dependent on the officer's action. So if the officers use physical force on a person, then of course there's a seizure. If the officers use show of authority and they tell them stop, if the person doesn't stop, as the court analyzed in Hodari, there is no seizure because the person can continue to leave. The difference in this case.
But if all that is necessary for a seizure is the touching of the person without having to exercise control, which is, I gather, what you're arguing, does that apply then to the other things that the Fourth Amendment says we can't unreasonably seize? In other words, if an officer comes in and just touches a bunch of papers on the table but doesn't do anything with them, is that a seizure?
No, Your Honor. And to answer that question, we need, as the court usually does, we look to the common law. And so in the common law surrounding the time of the founding, the word seizure can mean, it not only means taking possession. So when you have something like a piece of paper or an object, that's when you must take possession. And this actually is the case in two cases that our friends on the other side cite, the Charming Ship Sally and the Josefa Segunda cases, both of which revolve around ships that were seized that could only be seized if they were captured. However, those are objects. In this case, we have the seizure of a person. And so when we say the seizure of a person, it activates the common law of arrest. And because it activates that common law of arrest at the time of the founding, that common law of arrest only requires that there be the intentional physical force on the body of the suspect, the arrestee.
So counsel, under your definition, a person can be seized multiple times. In other words, each gunshot that hits the person counts as a seizure. And then if they happen to grab the person's hair or kick them, that's a separate seizure. If they knock the person over, that's another seizure. In other words, a person can be seized a dozen times or more in one altercation.
I didn't potentially. I think potentially yes, because we argue that a seizure is a single act. However, that can be construed either way as well, Your Honor, because the application of physical force in this case was the use of deadly force, and in that instant. So whether or not the court wants to analyze that it's an individual seizure when each bullet hits her, or that the overall application of deadly force to her that was the seizure, we believe that either way, it's still the predicate on all of that is that there was a seizure that occurred when the physical force applied to her.
Wouldn't it be just a cleaner rule for us to apply and for courts to apply in the future that a seizure is when you're actually detained, and that these skirmishes that lead up to detention aren't seizures? It just seems like just very difficult for judges to administer going forward. Not that we can't, not up for a hard job, but this seems like a lot you're asking us to do.
Well, yes, Your Honor. To answer your question, if we confine the definition of a seizure to be successful when detention occurs, we ultimately end up scrutinizing the suspect's actions rather than the government's actions. And so the framers aim to protect the people from government officers, and this protection can only activate when the suspect is in control of an officer. A ruling for petitioner would not create an expansive definition, rather it would linearize when a seizure occurs, and Fourth Amendment excessive force violations can be issued on that ground. We pray that you rule in favor of petition.
Great, thank you very much. And once the microphones switch around here, we will now hear from the respondents. You may proceed when you're ready.
Mr. Chief Justice, and may it please the court, my name is Kashish Bastola, and my co-counsel Anita, Ashok, and I represent the respondents in today's case. Would the court benefit from a brief recitation of the facts, or maybe begin with our arguments?
You probably can begin with the arguments.
Your Honor, the question presented before the court today is whether an unsuccessful attempt to detain a suspect by use of physical force constitutes a seizure within the meaning of the Fourth Amendment, or must physical force be successful in detaining a suspect to constitute a seizure?
Well, let's go back to one of my early questions to the other side. And the suspect's arm was immobilized by the gun shot, okay? She didn't have any further control over her arm, did she?
No, however, the control.
Isn't that a seizure? Somebody takes your arm away?
No, Your Honor, that would not be a seizure, as the petitioner maintained an unlimited and unrestrained freedom of movement. And
No, couldn't move the left arm, right? Correct? Couldn't move the arm.
Yes, her left arm was paralyzed. However, we look to cases such as Terry v. Ohio, where they defined the original definition of a seizure, which states that there must be some restraint to the person's liberty. And in US v. Jacobson, they defined that restraint to liberty as restraint of the person's freedom of movement, which was not terminated or restricted in any way, because the petitioner was able to travel over 75 miles from the grasp of the officers. She was not anywhere near them, and she was not in any sort of custody or possession of the authority.
Let's say instead of immobilizing her arm, it immobilized her mouth. Couldn't speak. Isn't that controlling a liberty right? Freedom of speech?
We don't believe that that would fall under a Fourth Amendment question, because as we are defining liberty, it would be freedom of movement, and she would still have that freedom to move herself away from the authority.
we also look to Brooks v. Gainesville, which tells us that just the mere use of physical force alone cannot constitute a seizure. And, just because a part of, the petitioner's body may be immobilized, that does not affect her freedom of movement in any way. And going back to what my co-counsel just said about Terry v. Ohio, footnote 16 about Terry v. Ohio tells us that an unrestrained and unlimited freedom of movement does not constitute a seizure.
And we urge the court to look at more recent past precedent, which would be Brennan v. California, Brower v. County of Inyo, along with Terry v. Ohio, like we mentioned, along with multiple dictionary definitions, such as Samuel Johnson's 1755 dictionary to even the modern 2014 dictionary, which all define a seizure as requiring some sort of possession by the authority of the suspect, which did not occur in this case.
Counsel, if we're looking at precedent, isn't our decision in Hodari probably the most applicable precedent here, where we talked about the circumstances of a touching and said that touching might itself qualify as a seizure?
We see Hodari D as dicta, and we see it to not be relevant in this current Fourth Amendment question before the court today, since it is not only factually removed, but it also relies on a common law argument, which respondents believe to be as well irrelevant to the current question at hand. We also look to footnote 2 of Hodari, which we mentioned in our brief, which tells us that a common law tradition does not dictate the ruling of a Fourth Amendment question such as this one today.
We look to, like I mentioned before, the dictionary definitions of seizure from the founding generation, from this common law era. The 1755 Samuel Johnson Dictionary defines seizure as the act of taking forcible possession. The key word is possession. In this case, the petitioner was not taken under any possession or custody of the authority. And we see this same definition remaining consistent throughout our history, as the 2014 Merriam-Webster Dictionary of definition of seizure is defined as the taking possession of a person or property by legal process, which simply did not occur in this case at hand. The petitioner maintained her freedom of movement and was not taken into any sort of custody or possession by the authority. So we urge the court to realize—
Don't some of the early dictionaries or maybe some of the common law sometimes equate seizure with arrest? And isn't arrest sometimes temporary or fleeting?
Some common law examples do suggest that a seizure is synonymous to an arrest. However, a review of this court's past precedent tells us that that public interpretation, or that interpretation under the Fourth Amendment of a seizure, does not always align with an arrest. And we hope to establish a clear test of what a seizure is through the ruling of this case, unlike what the petitioner is seeking, since in the petitioner's brief, they mentioned that a seizure is a single act and not continuous. However, just now, moments ago, the petitioner is claiming that it is possible to have multiple seizures. So we're simply seeking to set a clear and not blurred test or standard for what a seizure is under the jurisprudence of the Fourth Amendment.
Additionally, utilizing the petitioner's definition of seizure would cause the court to need two separate definitions of seizure under the same amendment. Like they mentioned, we would need a definition for the seizure of a person, which in their understanding would be any sort of mere touch or any application of physical force. And we would need a separate definition for the seizure of an object. However, in ruling in favor of respondents would allow seizure in terms of a person and in terms of an object or their possessions to be defined as taking possession or custody of that person or that object.
Doesn't your rule create some line drawing problems too? In other words, how long does a person have to be seized before they're seized for constitutional purposes? In other words, if the officers have someone detained for 15 minutes, then the person flees, has the person been seized?
Well, we agree that a seizure is a single act and not a continuous fact. But where we're drawing the line is that a seizure takes place when the suspect's freedom of movement is terminated. The moment that the suspect stops or their movement has been terminated is when a seizure takes place. So
under your rule, a person can be seized multiple times too. They stop someone for 30 seconds. And the person flees again. They stop them for 2 more minutes, then they flee again. Those are all individual seizures.
Well, ultimately, the suspect has not been seized because ultimately they have maintained.
Well, I thought you just told me if they were detained, if their movement was detained. I can't remember what qualifier you used fully. It was a seizure, but here the person's been detained for some measurable period of time, but then they escape.
No, the first moment that their freedom of movement has been terminated is the moment that a seizure has taken place. And that's where we are drawing the line.
All right, well, let me ask it this way then. Instead of getting hit by the bullet in the arm, she got hit in the leg, fell down for a second, and got up and started walking on the one leg. Was there a seizure?
Most likely there would not be a seizure, since the police officers, respondents in this case, would have had an easier ability to detain or to seize the petitioner. However, because the petitioner was able to travel over 75 miles, there clearly was no restraint to her freedom of movement simply because of her immobilized arm. So it's important to recognize, going back to Terry v. Ohio, that there was no restraint or no limitation to the petitioner's freedom of movement.
In your brief, and I'm a little confused by this maybe, so you can straighten me out. In your brief, you pointed to the test from Mendenhall, and you said that a seizure would occur when a reasonable person believed that he or she was not free to leave. But Ms. Torres left. So what does that mean in terms of whether there was a seizure?
Going back to the facts of the case, petitioner originally believed that the respondents were car hijackers who were not, she did not initially believe.
So whether it's a seizure depends on what is in the mind of Ms. Torres and not dependent on the intent of the officers?
Well, based on the Mendenhall test, yes, we do believe that the Mendenhall test tells us and sets the standard that if the individual is under the assumption that, you know, that law enforcement has them detained, or that they are you know, under suspicion for any reason, and that their freedom of movement is limited, then that would constitute a seizure. However, clearly petitioner did not believe that they were police officers initially and fled the scene over 75 miles to a hospital.
And when we look at the intent of the officers, we can look to Broward v. County of India, which highlights that the officers need to intentionally acquire physical control or possession of the person in order for a seizure to have taken place, which again is not what occurred on that day. We would also like to highlight that in Adams v. City of Auburn Hills, the court highlights that the use of deadly force alone is also not enough to constitute a seizure, on the grounds that the suspect has the ability to leave at any given time. So we see time and time again that the court has ruled that a termination of the freedom of movement needs to occur in order for a seizure to take place.
So what's the problem with, you made this point earlier, what's the problem with treating property different than individuals? Because property is inanimate, typically it doesn't move, and so it just seems like a totally different circumstance than an individual. And you were saying there's a big problem maybe for the courts and administration of the rule, but I'm not sure I don't fully understand why that's the case.
Well, creating one singular definition of a seizure would just create a clear line and a clear understanding for both law enforcement and citizens to understand that a seizure is equated with possession, and would just allow law enforcement officers to fulfill their duties without, while understanding clearly what the rules are.
And with the issue at hand with a moving vehicle, we also have seen throughout history and throughout the history of this nation specifically, that with moving vehicles that involve militarized conflict, especially in warfare, we look to the Josefa Segunda, which gives an example of how a seizure with passengers on a moving vehicle requires complete possession of that vehicle. So we do refer to that early example, as well as what the facts of this case at hand today to support that notion.
And our friends on the other side had mentioned that in their brief that a bullet wound which inhibits any sort of movement effectuates a seizure. And we completely agree with this, actually. But when we look at the case at hand, we see that even though that she was struck with those 2 bullets, there was no restriction on her freedom of movement, no restriction or termination of her freedom of movement. And we don't see any case law or precedent supporting the idea that it's supporting the connection between individuals' bodily integrity and a Fourth Amendment violation. So that our friends on the other side just saying that any sort of bodily injury by officers constitutes a seizure is very problematic and simply doesn't apply. And
in petitioner's brief, they also claim that that ruling in favor of respondents today would exchange private interests for public interests. They claim that civil liberties and individual liberties would be severely threatened by ruling in favor of respondents. However, instead, we believe that ruling in favor of petitioner actually weakens the power of the police to protect personal liberties of the people. It would hinder their ability to keep their municipalities and their communities safe. And we believe that ruling in favor of petitioner would also—
Council, isn't there, I mean, there's also this reasonableness question too, right? So, I mean, maybe the other side's rule creates more instances to allege an improper seizure, but it has to be unreasonable, right? So isn't that the safeguard for officers?
And we believe that, and that the reasonableness should be evaluated in or it was evaluated in the Section 1983 claim that was originally brought up. And in our brief, we mentioned qualified immunity for that reason to, give context as to the origination of this case. But we do believe that this would severely hinder the ability of police to protect their communities and to protect individual liberties. So
only when they act unreasonably. So
well, reasonableness wouldn't be
ahead.
considered in defining seizure. It would be considered after the fact. If we conclude that a seizure has taken place, then we would examine reasonableness in determining whether the officers were protected by qualified immunity or not. So therefore, we urge the court to uphold the ruling of the 10th Circuit Court in all respects. Thank you.
Thank you, counsel. And now we will go back to petitioners who have 5 minutes of rebuttal.
Mr. Chief Justice. Wait for the time. Okay, Mr. Chief Justice, and may it please the court. So in our response today, we will cover 4 topics: the common law, Hodari, government administrability, and other precedents. So first, to talk about common law, the opposing counsel points to the definition in Samuel V. Johnson's dictionary that says that seizure is taking of possession. However, I'd like to point the attention of the court to the definition of the verb arrest in Samuel Johnson's, that same dictionary, defining an arrest as any seizure of the person. It is quite a blatant and obvious sign that at the time of the founding, this was published in 1785, the arrest was equivalent to the seizure of the person, which is why on our side, we implicate the common law of arrest in our analysis.
Although arrest strikes me as like a final action. I mean, I know the definitions kind of go all over the place. Just my own instinct is that when I'm arrested, I'm finally seized and detained and I'm not going anywhere.
Of course, Your Honor, yes. And our understanding of that word today may be have more of a finality to it. However, as the court says in United States v. Southeastern Underwriters Association, the court must construe words in the Constitution to mean, the court does not construe words in the Constitution to mean more narrow than what they had at the common parlance at the time of the Constitution's founding. And so at the time of the Constitution's writing, the common law of arrest involved just the touch of the grasping of the arrestee. And that's something
is that a civil arrest you're referring to, or a criminal arrest, or both?
That would be a civil arrest, Your Honor.
Okay, and what we're dealing with here are criminal arrests, right?
Yes, yes, Your Honor, but the court has looked to civil arrests as a guidance for criminal arrest, not only in this case, but also in Atwater v. County of Lago Vista, and that is a line of analysis that the court has taken before.
So you're saying that if Hodari D says that arrests are seizures, are you saying then, based on Samuel Johnson's dictionary, among other things, that all seizures are arrests? And that's expanding a little bit on Judge Radler's question. Because if you are, What does that mean for somebody who gets momentarily, even a Terry stop, momentarily stopped by the police? Does he then have an arrest record?
No, Your Honor. No, Your Honor, because the common law of arrest, it's not necessarily saying that an arrest is, we're not defining a seizure of a person as an arrest in the modern day sense. It doesn't necessarily mean that they have an arrest record, but that verbiage, the seizure of the person, activates the common law of arrest around the time of the founding. And that common law includes the fact that the touch is enough to constitute an arrest. So we're not necessarily saying that people are going to have arrest records because of seizures of the person, but because seizures of the person implicates that common law, then we must look to that common law in order to decide what protections are afforded to people
Is
today.
it your view then that a touch on the shoulder for a police officer to start a Terry stop and ask a few questions is a seizure?
No, Your Honor, and this is actually a question that has been addressed by the court in INS v. Delgado. In that case, a group of immigration officers were walking around a factory, tapping people on the shoulder and asking for identification information. And the court ruled that that was not a seizure because, number one, there was no intent to actually seize the person. It was a tap on the shoulder to ask them a question. And so it depends on the circumstance. If there is the intent to seize, if that action from an objective point of view, it looks as if it is intended to seize the person, then, and if there is physical force involved, therefore there must be a seizure.
Your Honors, I'd like to reference and move to a part of what Mr. Chief Justice mentioned before a respondent's argument, and that is the government administrability factor. What do judges do, and isn't it more difficult for judges to enforce a ruling for petitioner? And we have two responses to that. Number one, it isn't, and that is because of a two clear step test. Number one, there must be physical force enacted on a person for a seizure to occur. And number two, the intent must be there. And that two-step test is a very easy test to enforce in almost any circumstance. And then the next thing is a radius. Yes, Your Honor.
Why wouldn't it be easier just to leave these questions to matters of state law? In other words, isn't state law going to address this kind of conduct through battery or assault laws? And why should we be reviewing these through a federal lens under the Fourth Amendment?
Well, of course, Your Honor. And yes, there are state tort and battery laws that can cover circumstances like this. However, the question that we are necessarily addressing today is whether or not the Fourth Amendment also, as you said, includes that. And I'd like to point the court to a definition. The overriding function of the Fourth Amendment is to protect personal privacy and dignity against unwarranted intrusion by the state. That's from Schumer v. California. And so that case shows that any kind of intrusions, arbitrary intrusions, must be addressed in the Fourth Amendment. And this is an arbitrary intrusion. Therefore, that is the analysis path that we should take.
And we see that our time is now over. And so we rest our case and we pray that you rule in favor of petition.
Great, thank you. Thank you very much. Thanks to both teams.
That was fantastic. All right, I'm going to put the students in the waiting room for a few moments so the judges can talk. I'm going to pause the recording here. We'll be back in a bit. Thank you so much. Begin.
Well, that was really outstanding argument. So we'll give you some feedback afterwards. But I just wanted to we all thought this was outstanding, and it was a very, very difficult decision, both on who our best individual presenter was and which team presented best overall. So we'll start first with the individual award winner. The best individual speaker was Senou from Basis Peoria. Congratulations. And our best team was the team from Frisco CTE Center. So congratulations to the respondents for the best overall team. As I said, this was a really, really wonderful presentation, and I think we'd all like to sort of give you our individual thoughts on your presentations. I'm going to start first with a real Supreme Court justice, and that's Justice Pat Fisher from the Ohio Supreme Court.
Good morning out west. I want to say, I said there when we're discussing it, that the four of you did better than most lawyers I see every day. You guys knew your case. For the petitioners, if you notice, I tried a trick on you. I gave you a question, kind of making you feel like I was heading your way, but then kind of flipped it on you. But you handled it very well, I thought. And I thought you guys did great. Respondents, same. I didn't do quite that same with you, but I asked more direct questions. And you guys did a great job answering the question, because I can tell you, there are young lawyers that appear in front of us at the Ohio Supreme Court that sometimes refuse to answer the question. And that doesn't help their argument at all, because I mean, they can always say, hey, Judge, that's not the case here. Facts are different, or see Smith versus Jones, which is like that. But some of them just refuse to deal with it if they think they're giving in something. But I never got the feeling that either side, you were giving in. You were responding, you answered the questions, and then you went on. And that's the sign of a good oralist, good argument. And you guys should be very proud of yourselves, the fact you got here and the job you did here. So congratulations to everybody. Allison.
Well, I would echo what Justice Fisher just said, and I would add to that that you, all four of you, did a very, very nice job of tying your responses to the authority on which you were depending. And not everybody does that when they're arguing before a court of appeals, but you all did that very well. You also, your presentation styles were different, but each one of you had an effective way of talking to the court. Sometimes lawyers forget that oral argument doesn't mean that you're fighting with the court. You're presenting, in the classical sense, an argument, and all four of you have that down very, very well. If you had been in front of us in person, it's pretty clear to me that you also would have done very well with maintaining eye contact with the judges. And you were, each one of you did this very well. You were carrying on a conversation with us as we were asking questions. That's a skill, and it's one that I compliment all of you on. I have to say that when Judge Radler said that this was a difficult decision, I want to make sure you understand, in terms of the winning team, this was a split decision. We weren't unanimous. So you all need to understand that we thought all of you really, really did a fine job. I will look forward to the time many years from now, if I'm still alive and kicking, seeing you before real courts, because you're well on your road. Congratulations to all of you.
Yeah, I will echo what my colleagues said. We were, this was a very difficult decision for us, but I just really enjoyed watching all of you and hearing from you. I have a daughter who's 16 and participates in a mock trial competition, so it's more like a trial court level. And that's hard because you have witnesses and you don't know what the witnesses are going to say, but you of course don't know what we're going to ask you. And all of you were so poised and so quick to respond. You handled those questions so well. You know, the real trick, it's called an oral argument, but it's really a conversation with the judges. You don't really want to feel like you're arguing with the judges. The judges might be a little hostile sometimes towards you with an aggressive question, but you really want to, you don't want to be flustered by that. You just want to make it conversational, just like you're talking maybe to a friend or a teacher or something. And I thought you all were so exceptional at that. So I really commend you. You also were quite good about stopping when we asked questions. Sometimes lawyers don't do that. You answered the question. And then I thought you also were very good. If we didn't have a follow-up, you then went on to your next point. Sometimes lawyers in our courtroom sort of get flustered because they get off the script and they have trouble getting back to it. And you guys were really proficient at just not skipping a beat. And I was one thing I thought you all did quite well was you not only want to sell the virtues of your case, but the really good lawyers will in an effective way point out the problems with the other side's case, because we need to know not only why we should rule for you, but why it's a problem, maybe in this case or future cases, if we adopt the rule that the other side wants. And I thought you were really seamless about that and really tactful. You don't want to be sort of mean, you know, or unfairly critical to their side, but you want to point at the problems in their side, and you all were really effective in doing that. So as Judge Batchelder said, it was a split decision and a very difficult decision, but just all four of you were outstanding. And I do hope to see you in the courtroom someday as well.
Let me jump in for a minute. I've been running this tournament now for almost a decade, and it brings me joy. It brings me such joy to see the next generation having this much of a commitment to the Constitution and our laws and our courts. You can be very cynical today if you read a paper or watch the news and look what's going on in our world. But when I see the four of you, bright young faces, arguing about common law cases, arguing about drawing lines, saying no, footnote 16 of Terry v. Ohio, right? It gives me such hope that our future is in good hands. You are our future generation, and Judge Batchelder's being modest. She'll be on the bench forever, and she'll be grilling you guys in Cincinnati in a couple of years before you know it. I can be sure of that. So I want to thank you. Also, if the coaches can just come on the camera for a minute. Students are only as good as their coaches, and their teachers have been so committed to them throughout this tournament. So Lee and Ben, I give you guys a round of applause. You motivate your students, you give them inspiration, you help them when they're struggling, you answer their questions, and you're sort of lurking in the background, floating around. But I know how much hard work you put into it. So the teachers are just so important. So I want to put my hats out to you guys. Thank you so much.
I am just delighted to have been asked to participate in this. I was not sure what I was getting into when Josh asked me to do it. And it is a morning extremely well spent. All four of you give me real hope for the future. You truly do.
And the four of you, I hope, as the former president of the state bar, you come to Ohio and practice. It would be great. But even if you never become a lawyer, the way you four handled yourselves is the way people should in our public discourse, making arguments on reason and not attacking the other side personally, which is a problem in our communities at this time. So whether it's, maybe you're at a zoning commission meeting and you're not a lawyer, and you're arguing something, remember your abilities here, so that you focus on the issue, you make reasoned arguments, and you don't personally attack someone on the other side. It's heartwarming to see you all do this. Thank you.
And if you have questions from the students or the coaches for our judges, we're happy to hear your questions. This is a rare opportunity you get, but hopefully you have some things you might want to ask us.
Please feel
Don't
free.
be shy. You weren't shy before.
Yeah, it's a chance to yell at a judge.
Well, let me just start off by thanking Josh and three justices today. This was a wonderful opportunity for our students, and they were thrilled to be in the competition today. And I just echo your words as well. And I also want to congratulate Frisco for a really nice job. And it has been a journey for us in this meeting long distance like this. But and I have been teaching the Constitution for 10 years, and I see a real interest. The students always come back and marvel at our Constitution, and just like what Josh just said. And Justice Fisher as well. It's a real great hope for our future. And we really enjoyed this tournament, and we thank you for being here this morning judging for us.
Thank you for the work you're putting in to support these students. It is critically important, and bless you for it.
Thank you.
I'd just like to echo what Mr. Tran said. I want to thank the justices for being here this morning. I've had teams in this competition on and off since it started. And I just want to say, this was all for my kids, especially. This was a weird year. We were hybrid and face-to-face and some virtual people in Texas for the year and everything. And It's all their hard work. They put in all the time, really outside of class for this. And I'm sure the other team did as well. It was just a strange year to be doing anything. And I think both teams did a great job. And it was fun to sit here and watch it this morning. I want to thank you guys.
Thank you.
Thank you so much for this opportunity. It's been very educational, and thank you to the coaches. Thank you, Mr. Ewald and Mr. Tran, for everything that y'all do. And also thank you to Ayaan and Senou. We have a lot to learn from y'all too. Like, that was, every round that we've competed with y'all has been very,
tough competition
it's
for
just-
sure.
yeah.
Yeah. So thank you so much for this opportunity.
Thanks. We'd say same going back to you guys too. It's been a tough competition all the time, and thank you for that. Thank you to our judges, and thank you to Josh for organizing this awesome competition. I had a kind of a question on I mean, are there any other ways that for the judges or anyone here who has knows to get involved in, like, in law and like maybe interning or stuff like that? Like, do you have any recommendations for how to get started with that? What are some first steps that we can take towards that kind of?
It's a good question. Judges?
Well, it's hard to have young people interning when they haven't had any legal experience.
Mhm.
On the other hand, you guys, all four of you, are obviously extremely quick studies. Many years ago, I had an intern who was in college. She was not in law school, but she wanted to find out about how a court worked. And so I said, okay, fine. So she spent the summer with us and she learned a lot. She then went on to law school. And when she was in law school, she took on representation on a pro bono basis with the approval, of course, of the court and the bar, challenging a law in the state where she was in law school. And she ended up getting the Supreme Court of that state to overturn the law. And I always thought, well, I'll take some credit for that. I had her in chambers as an intern. So there may be some of those opportunities available, even though you're not even, I assume, are you kids all seniors this year? You're not even that? What,
Right.
where are you? What year are you?
I think we're rising seniors, so we were juniors this past year, and now we're seniors.
I'm a rising junior and she's a rising,
I'm going to college this next year. So I was a senior.
or I'm a rising senior, sorry.
Where are you going to college?
Trinity University in San Antonio.
Good for you. Well, the opportunities are a little bit, probably a lot more limited until you have a little bit more education under your belts, but keep looking for those opportunities. Because, if you, it's a sort of a nothing ventured, nothing gained. You reach out and all four of you are extremely impressive. You may be able to impress somebody who says, I don't care that you don't, you're only in college or only getting into college, or you don't have any legal experience. Come spend some time with me and see what it's about.
Yeah, if I can just interject for a minute. Courts are open to the public. You don't need an invitation. Every court in the United States has, I think with COVID, they're open now. I think they are. Just go to a court and walk in, right? Go look at the docket sheet for the day. They usually posted on the front door, right? Who's here in case in a given day, and just watch, right? You're in San Antonio, you're not too far from New Orleans. You guys are in Phoenix. Every now and then, Ninth Circuit sittings in Phoenix. Go watch it. Just walk into court and watch. They actually, in Arizona, they visited with some of the Supreme Court justices a few weeks ago, which was nice. And they met some judges in Texas as well. So walk into a court and just sit there and watch. And you'll learn so much. We don't know what the case is, but you'll learn about it, which is just a sort of fun way to get yourself situated.
And I can say that our court, you can watch live or streaming, because we're all on TV every day that we're in session. And you can go online and the press department sends out a preview of each case. So that's another way to kind of watch and learn. And you also see some mistakes people make. And so another way, and I don't know about other state Supreme Courts, but I'm sure some of them else are online live. But you can also watch us on streaming archived. You know, if you're really tired, but you can't get to sleep, you can turn us on late and watch a Public Utilities Commission argument or something. You know, get some shut eye. But the one thing I would say is, whatever you do well in college, do well in law school, but even college. Somebody asked me what I look for a law clerk. I look for three things. One, that did a good job in school. Second, somebody who worked, had a job while they're paying their way through school. And on balance, I'll take an English major or somebody who's done a lot of writing as an undergrad over, doesn't have to be an English major, but you could be a history, political science. Although one of my best friends is a very successful lawyer, and he was a mechanical engineer, but he did very well in school. So whatever you do well at it. Doesn't matter, really.
In terms of trying to get some experience with the law while you're still in high school, the best bet maybe would be to try to find a lawyer you could shadow for a day or two. Maybe find either a family friend who's a lawyer, might be willing to have you come to the office, maybe go to court with them for a day, or contact the local bar association and see if they have any programs at all for high school students to come and shadow or watch. I actually did that in high school, and I went to a sort of rural, not particularly fancy high school, but there happened to be a lawyer down the street, and they let me go for a couple of days and spend time in the office. So maybe something like that would work out. Might take some effort on your end to figure out, but that's a great initiative. And you all obviously have incredible initiative to have done this so well. So I'm confident you'll be able to figure out other things as you go ahead.
One final note. In today's world, you're up against some real pressures. And I would just say to you, each one of you has, as Judge Radler just said, shown real initiative. I would just urge you to be strong in your determination that you're going to pursue all kinds of ideas. You're going to read broadly, you're going to keep an open mind and not let somebody tell you what to think. And if you can do that, you will find that you have taken a big step towards real success.
I have a question specific for like joining or like having opportunities in the federal judiciary. So if I'm in high school, do you all have any tips for like how we can get involved with the federal judiciary, or like if we know that we would want to, you know, seek a position in the federal judiciary one day?
That's some initiative, huh?
Well, let me just say that getting onto a federal court is a lot like being struck by lightning. And I'm not sure that I think that there are, I'm not sure I think there are much by way of opportunities out there to get involved, but going to court and watching what goes on is probably the best one, at least to decide that this is something that you're really interested in. And then see if you can find a lawyer who practices extensively in the federal courts and get him or her to give you some opportunity to watch specifically what that practice does.
A good tip is to be roommates with the president. That's a good tip. Just, you have to figure who that is. But if you're, future roommate in college with the president, then you're in good shape. Well, mostly joking, but not really.
Shoot higher, shoot for ambassador. You can live in Europe for a few years. What I was going to say is the thing you can, it's really obtainable, is to become a law clerk for a judge. So you have to go to law school for that. But a lot of lawyers get involved with the federal system during law school, maybe during internship, and then right after law school as a law clerk, because we all hire typically new grads or newish lawyers to be our law clerks for a year or two. And that really gives you a lot of insight into how the federal courts work. Becoming a judge, there's lots of ways that can happen, but it does usually require some fortuity. But I would encourage you all, if you go to law school, you should definitely think about clerking for a judge. I think you'd really all enjoy that experience.
Yeah, I clerked on the Sixth Circuit, the court where Judge Batchelder and Radler sit. I clerked there right after law school. I had a wonderful time. one of the best jobs you'll ever have. Any other questions from the students?
Yes, actually. Specifically concerning, since we have a lot of time till law school, I'd say, when we figure out like possible places to intern at that aren't specifically appellate advocacy related, what would you recommend? Because I'm very interested in international affairs and global developments, and I don't know whether that'll stray me away from appellate advocacy or not. And so I just wanted to hear from you all.
Are you interested in working as a lawyer, but in international affairs, or not being an appellate lawyer? Is that what you were saying?
I actually don't know, but I just know that I like a few things and I want to try them out.
Well, you should kick the tires on a lot of them. There's probably programs in your high school. And then when you go to college, there'll be opportunities to do all kinds of things and, pursue interests. So for me, I had a little bit of interest in politics and got a little bit involved in high school and then in college, and didn't ever run for office or anything, but that was something I was just interested in and didn't have much experience with. So once you get to college, especially, but also during summers, there might be ways to volunteer or do online programs or that kind of thing. But yeah, curiosity is a real strength, and you should pursue it. And because you never quite know what will interest you. And even if you become a lawyer, whether you're a lawyer who goes to court, or you're a lawyer who negotiates deals, or you're a lawyer who works at a company or works in the government, there's all kinds of different lawyers. And so you should certainly not limit yourself by just sort of thinking there's one thing you want to do and that's it. You're right to be really curious about a lot of things.
That's great to hear. Thank you.
Anything else? Well, then let me maybe bring this to a close. I want to say thank you to the judges, to Judge Radler, to Judge Batchelder, Justice Fisher. You're all very busy. You have very important jobs, and it means so much to me that you take time of your day to grill and ask these kids questions. But I assure you, they will never forget this. Long after you and I are all gone, these kids will be sitting on state Supreme Courts and sitting on the circuit courts, and they'll remember this day. So thank you. To Mr. Tran, Mr. Ewald, thank you. You do an important job. It doesn't always get the credit it deserves, but teachers do such an important job. And to the students, thank you. You really give me hope for our future. And unless anything else, I will gavel. I don't have a gavel, but I will virtually gavel this to a close and say thank you all so much. Please, any questions, you're always open to come talk. Thank you so much, everyone. Bye-bye.
Thank you. Best of luck.
Thank you.
Okay.